I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
This case opens with an explosive moment. A prosecutor calling out what she describes as gender-based disrespect inside the courtroom. From the very first seconds, the tension is undeniable. She's not debating law or evidence. She's challenging professional conduct. The case is State of Michigan versus Cyrus Abadi, but the courtroom battle we're seeing isn't between prosecution and defense. It's between two attorneys accusing each other of misconduct. Right here, the prosecutor claims she's being treated differently because she's a woman, setting up a powerful confrontation about ethics, professionalism, and gender bias in the legal system. Stay tuned, because what follows is one of the most charged exchanges we've seen in recent Michigan courtrooms.
To put on the record, because I think the last communication I saw, Mr. Dawes had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I'm going to...
Here, the prosecutor takes a deep breath before stepping into emotional territory, being accused of lying in a public filing. That's a serious allegation in legal circles. It can damage a career overnight. She's visibly shaken, yet careful to maintain decorum. Notice how she reiterates her record of defending opposing counsel in the past. This isn't just defense. It's image repair. She's appealing to the judge's understanding of reputation and professional integrity, which in law often matter as much as the case itself. It's a tactical move meant to establish credibility before the defense has even spoken.
But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that sets you. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people.
This section highlights a critical theme: respect versus rivalry in the courtroom. The prosecutor acknowledges disagreements are part of the job, but says this time it's personal. That distinction matters because if one side's hostility crosses into harassment, the court can sanction it. What's fascinating here is how she blends personal grievance with professional boundaries, implying that this isn't about hurt feelings, but institutional bias. It's both a legal argument and a social commentary on gender treatment in law, something courts are increasingly being forced to confront.
A working relationship, and I had no reason to believe that anything changed. I think I in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've had a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I haven't done, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin. And I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw.
Now we reach the evidence of the email. The line, "You can posture all you want, Marie, just don't think I'm not seeing through you," sounds straight out of a confrontation scene. But in court, it's devastating proof of tone and intent. She frames it as an unnecessary personal attack, and by reading it into the record, she ensures it's preserved in the official transcript. That's a strategic move. Once something enters the record, it becomes part of judicial review. This moment turns what was a private conflict into a public accountability issue, and she does it calmly, point by point.
Necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
The prosecutor doubles down here, asserting gender discrimination in open court, an incredibly rare and risky step. By saying she's calling it out, she transforms the proceeding from a legal debate into a statement against systemic bias. For viewers unfamiliar with courtroom dynamics, this is huge. Lawyers typically avoid emotional framing before a judge. Yet here, her controlled outrage reinforces her claim. She's not overreacting. She's standing against unequal treatment. It's both advocacy and personal defense, wrapped in one of the most candid courtroom monologues we've heard in recent cases.
Any other counsel, I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get—
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply, specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply.
This is a pivotal strategic turn. Instead of demanding an apology, she offers the defense counsel a chance to withdraw his statement, paragraph 5, from public record. That move shows restraint and professionalism, while subtly placing moral pressure on the defense. It tells the court, "I'm not vengeful. I'm ethical." From a legal optics perspective, this is powerful. Judges appreciate counsel who prioritize decorum. It's also a chance for the defense to de-escalate, if he takes it. But as we'll see, things only get more heated from here.
He might want to consider. And you're not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I'm
Here the judge steps in, breaking neutrality to deliver what's almost a lecture on professionalism. His tone carries disappointment, not outrage, which is worse in a courtroom. When a judge says, "I expected better from you," that's a warning signal to the entire bar. It's also clear he views the defense's actions as personal rather than professional. This exchange reveals a subtle power dynamic, the court reinforcing decorum and boundaries after the defense appears to have crossed them. The tension shifts from lawyer versus lawyer to lawyer versus the bench, a dangerous position for any attorney.
I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Now, defense counsel strikes back, accusing the prosecutor of misrepresentation. His tone is defensive yet condescending, attempting to recast her credibility as the issue. It's a common strategy when facing professional conduct criticism. Turn the attack into a legal disagreement. But pay attention. He references a prior hearing, September 23rd in chambers, suggesting context the public hasn't seen. It's his way of creating doubt about her version of events. However, once the debate veers into accusations of misinforming the judge, the defense risks being seen as disrespectful, especially after the earlier warnings from the bench.
The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion, is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench.
The judge's tone shifts to firm authority here. This is no longer about tone or bias, it's about the law itself. He clarifies that Michigan's rape shield statute does apply at preliminary examinations, emphasizing victim protection above procedural debate. This is the heart of the case's legal argument. The judge's point: once sensitive sexual history is revealed, the cow has left the field. It can't be undone. This statement effectively dismantles the defense's procedural claim and reminds everyone that legal ethics exist to protect both justice and dignity in the courtroom.
There. And so it doesn't make any sense. Moreover, Mr. Das, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it. I put it in writing. I provided the court with the authority. What in fact I did was I did not submit an advocacy piece. I did not. I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now, what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing. It is published.
But I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law says. That's what the court rule says, not with the defendant. That is not what the rule is. So, if I can go back once more. The very core item that's at issue is whether defense counsel before exam needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
Here, the defense lawyer's frustration peaks. His, "Maybe that's because you wear the robe and I don't" quip is a dangerous crack in courtroom decorum, practically daring the judge. In professional terms, this borders on contempt, yet it also reveals how deeply he feels wronged or misunderstood. The clash exposes a larger issue in legal culture, how ego and emotion can overtake the law itself. It's a reminder that courtroom battles aren't just about statutes. They're about respect, restraint, and reputation, all of which hang in the balance right now.
Be at odds with it because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that Fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tanner, you will prepare the order. I will sign off, and that is the ruling of the court.
And just like that, the gavel falls. The judge rules that the rape shield statute does apply at the preliminary stage, closing the door on the defense's argument. Tanner is instructed to draft the order, marking a professional vindication for her after a heated and personal conflict. Beyond the single case, the message is clear. Gender bias, hostility, and disrespect have no place in the courtroom. The rule of law must rise above emotion. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more deep dive courtroom breakdowns where we unpack the drama behind the decisions.